is that
Yes, yes.
you should give the grounds of arrest, otherwise it becomes illegal.
And today I'm given to understand, my lords, in Arvind Kejriwal's other
Bail is granted.
It is granted. So, my lords, when in cases, my lords, where grounds of arrest is not given, it becomes an illegal arrest. Article 22, subarticle 1, my lords. All this comes out from there. Article 22, subarticle 1, it necessitates the grounds of arrest to be given, my lords. That is followed in section 50 of the CRPC. When you arrest, if you want to take a person to custody, you must give him the grounds of arrest. You may arrest, you may detain stop a person, but if you want to take him to custody, you give the grounds of arrest.
It's not on that.
In fact,
Whether it
out
is
of the grounds
coca,
of-
mocha,
grounds,
adella
yeah.
ilve illa. It is on the threshold. That is grounds of arrest not given, it becomes illegal. Even if the arrest is long ago and proceedings have proceeded further.
even
Yes.
Ultimately, when you arrest, even if you have filed a charge sheet in a given case, the Supreme Court says the grounds of arrest should be given. The grounds of arrest admittedly is not given, it is only a notice of arrest. That's what the Supreme Court has said. Then the arrest becomes illegal. Consequent action will follow. Interim bail head.
other matter is the bail matter, grounds of arrest, clarification my lords wanted. My lords, I had pointed out on 3 distinct aspects.
No, now that now your regular bail is rejected, is it?
Yes, yes,
But
my lord.
my lords, regular bail will have nothing to do
And
in so
punishing.
far as grounds of arrest, because my lords, even in the Supreme Court matters, it all came up through writ petitions, my lords. When the arrest itself is illegal, I don't have to seek bail. I can point out that the arrest is illegal. These are matters where arrests are illegal. They become void, my lords. That's what Supreme Court holds. And not in 1 case, but in 3 cases, my lords. Pramod, then
Names bidi parvai, don't worry.
Rabi, and then Arvind Kejriwal. And today I'm given to understand, my lords, in Arvind Kejriwal's other
Bail is granted.
It is granted. So, my lords, when in cases, my lords, where grounds of arrest is not given, it becomes an illegal arrest. So, I don't have to say illegal arrest and then all the remand becomes illegal. Bail stands on a different footing. I will have to point out in a bail a prima facie case for grant of bail. So, my lords, what comes in bail is the tripod test that I will cooperate, but that is not so when it comes when grounds of arrest is not given. And that is how it is.
ಅಲ್ಲ
been
grounds
said.
of arrest admittedly is not given. ತಿಳುವಳಿಕೆ ಪತ್ರ ಕೊಟ್ರಿ ಅಷ್ಟೇ ನೀವು.
Yes, my
Also,
lords,
ಇದರಲ್ಲಿ
grounds of arrest admitted.
just one submission. Though there is a 1 sentence grounds of arrest, there are 5 points involved, my lord.
No, that is only notice of arrest.
ತಿಳುವಳಿಕೆ ನೋಟಿಸ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಬಟ್ ಅಲ್ಲಿ ಅದೆಲ್ಲ ಕಂಟೆಂಟ್ಸ್ ಅಲ್ಲಿ ನೋಡುವಾಗ ತೆರವುಗೊಳಿಸು ಕಂಡು ಬಂದಿದೆ ಅಂತ ಹೇಳಿ ಮುಂದೆ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲಿ 5 ಪಾಯಿಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಸರ್ವೆ ನಂಬರ್ ಹೇಳಿದ್ದಾರೆ ಸರ್, ಪರ್ಟಿಕ್ಯುಲರ್ ಸಬ್.
Notice of arrest will not replace grounds of arrest. But now that your bail is rejected,
ಅಂಡ್ ಇದು ನಾನು ಐ ಹ್ಯಾವ್ ರಿಲೈಡ್ ಸಾಧ್ವಿ
ಅದು
ಕೇಸ್
ಹಳೇದು.
ಅಲ್ಲ ಸಮಯ ಅಲ್ಲ ಅಲ್ಲಿ ಮೈ ದಿ ಅಕ್ಯೂಸ್ಡ್ is arrested under coca. He was remanded to he was produced before the coca court, special court. The remand was ordered passed by the special court coca, and his bail petition rejected by the coca court, special court. Under hence there is provision under the 12 section 12 of the coca that is to be invoked, not 482, my lord. The specific provision is there. This is what the ಇಲ್ಲಿ ಸಾಧ್ವಿ ಕೇಸ್
Sir,
ಅದನ್ನ ಹೇಳಿ.
482 don't tell. I have no
Well,
power to consider.
I may be permitted to
Corrections, my
furnish.
lords, whether it is UAPA, whether it is COCA, whether it is any other special enactment, if at all, my lords, grounds of arrest is not given, the arrest is illegal. That is what is laid there. Even that was cases of UAPA. UAPA. And also, my lords, one more very important aspect may be, my lords, Article 22, subarticle 1, my lords. All this comes out from there. Article 22, subarticle 1, it necessitates the grounds of arrest to be given, my lords. That is followed in section 50 of the CRPC. When you arrest, if you want to take a person to custody, you must give him the grounds of arrest. You may arrest, you may detain stop a person, but if you want to take him to custody, you give the grounds of arrest. So 50 with Article 22(1) makes it very clear that's exactly what the Supreme Court considered. And they said the arrest is illegal. And they said you have to release him. So, my lords, parameters of bails don't come here, whether it's special enactment or whether it's IPC, it's one and the same. This would be the yardstick, my lords, to see whether the arrest is illegal or not, remand is illegal or not. And especially in our case, my lords, where first case, they take me in, I get bail, I don't get released. They take me in the second case. Second case, after they finish the police custody, when I get the bail, they don't release me. Then in crime number 8, they take me in police custody. I come back to the lead case. When they leave me outside the prison, in crime number 8, they say, now we have invoked COCA, we'll take you back inside. That can never be done, my lords. I've given that whole sequence.
Just I mean permitted to file over.
ಕೊಡಿ ಕೊಡಿ
Judgment of the certified copy of the judgment of the
ಅವತ್ತು ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ
bail rejection. Because I relied Supreme Court ruling. Adru sah they have to challenge. Mokadalli ಆಗಿರುತ್ತದೆ ಕೇಸ್. Without adjusting the remedy under MOCA, there are remand orders ಇದೆ, produce ಇದೆ, bail rejection ಇದೆ. Hence my submission is that.
No, he is not on that.
In fact,
Whether it is COCA, MOCA,
grounds.
ಅದೆಲ್ಲ ಇಲ್ವೇ ಇಲ್ಲ. He is on the threshold. That is grounds of arrest not given, it becomes illegal. Even if the arrest is long ago and proceedings have proceeded further.
even after charge sheet, if a
for
charge
that-
sheet is filed also,
That's what Prabir says.
For that, my submission is that ಅಲ್ಲಿ Parbir
Fact,
case
my lord,
ಅಲ್ಲಿ
my bail, I'm
Parbir-
sorry, subject to correction, my bail has been rejected on a provision that has been struck down. 22(5),
Of COCA.
COCA, it is struck down.
You're not challenging that?
I'm sorry, my
You're not challenging that?
no, my lords, I may look at filing bail against that. That is altogether different, my lords. But if this arrest is illegal, my lords, my remedy is only this.
ಅದೇ same order what he gave now, ಅದೇನದು?
Same one. Which
ಅದ್ರಲ್ಲಿ-
I gave
ಅದ್ರಲ್ಲಿ-
notice, the last one, my lords.
ಅರೆಸ್ಟ್ ಲೀಗಲ್ ಅಂತಲೇ ಆಗಿದೆ. ಇವನ್ ನೋಡಿ ಸರ್ವ್ಡ್ ಸಫಿಷಿಯಂಟ್ ನಾಲೆಜ್ ವಾಸ್ ದೇರ್ ಅಂತಲೇ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು. ಯಾಕಂದ್ರೆ ಇದು ದಿಸ್ ಇಸ್ ಸಮಾಟ್
My lords,
ಡಿಫರೆಂಟ್
I
ಅಂದ್ರೆ
totally think I'm
first
covered by the three.
ಪರ್ಬೀರ್
rulings of
ಕೇಸಲ್ಲಿ
ethics.
ಫಸ್ಟ್ ಅರೆಸ್ಟ್ ದೆನ್ ಕಸ್ಟಡೀಸ್ ಆನ್ ಫಸ್ಟ್ ಅರೆಸ್ಟ್.
Arrest ಮಾಡ್ಬೋದು, custody
That-
ಕೊಡಕ್ಕಾಗಲ್ಲ.
see,
ಎಸ್
ultimately, when you arrest, even if the you have filed a charge sheet in a given case, the Supreme Court says the grounds of arrest should be given. The grounds of arrest admittedly is not given, it is only a notice of arrest. That's what
My
the
lord,
Supreme
that's-
Court has said, then the bail, the arrest becomes illegal, consequent action will follow.
Well, it's Article 22, sub-article 1, this is how it reads, my lord. No person who is arrested, so no problem with the arrest. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of his arrest. So you can first arrest us, but then you can't take us to custody till you give us the grounds. That is what Article 22, sub-article 1 says, and that's what the Supreme Court says now.
Yes, Ashok sir, arrest is different and custody is different.
ಅರೆಸ್ಟ್ ಫಾರ್ ಅಸ್ ಕಸ್ಟಡಿ ಬಟ್ ನಾಟ್ ಕಸ್ಟಡಿ
No, no.
ಫಾರ್ ಅಸ್ ನಾಟ್ ಯೂನಿವರ್ಸಿಟಿ.
Ah,
ಇಟ್ಸ್ ವಾಟ್ ಅಂಡ್
arrest is only temporary detention, custody is yes detention.
Stopping a person is arrest.
Yes,
My lord, I just, but then if you want to take me to custody, you give me the grounds.
Yes.
DP, clarification.
I don't want to reserve it because it's already piled up. Because
Because this is of bail, my lords may take.
I know
it as-
it has to, Tuesday, Wednesday ಹಾಕ್ಬಿಟ್ಟು ಅವ್ರು ಮಾಡ್ತೀನಿ.
Please.
Wednesday 1 PM ಹಾಕಿರ್ತೀನಿ.
Please.
Then ಮಾಡಿ.
Adu, my lords, that's the peak time, my lords, with so many cases are going on. We are hesitant to come in print and ask for.
ನೋಡು.
I'll request
Kindly,
you to make a mention at 1, my lords.
ಅಲ್ಲ ಸಬ್ಸ್ಟೆನ್ಸ್ ದ ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್ ಇಸ್
No, do one thing.
ಓನ್ಲಿ 1 ಪಾಯಿಂಟ್.
ನೀವು ಆಯ್ತು ನಾನು ನೋಡ್ತೀನಿ. ಅದು ನೋಡ್ಕೊಂಡ್ ಬಂದಿರ್ತೀನಿ. ಮೇಕ್ ಅ ಮೆನ್ಷನ್ ಎಟ್ 1:20 ಬಿಫೋರ್ ಲಂಚ್ 1:45 ಕೂತ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಪಾಸ್ ಆರ್ಡರ್ ಸೆಂಡ್.
ಒನ್ ಸಬ್ಮಿಷನ್ ಲಾಸ್ಟ್.
Sorry, my lords, we're eating into your lunch time then, my lords.
ಎಲ್ಲ ಟೈಮು ಆಯ್ತು.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫೈಂಡಿಂಗ್ ಇಟ್ ವಾಸ್ ವೆಲ್ ವಿದಿನ್ ದ ನಾಲೆಜ್ ಆಫ್ ದಿ ಅಕ್ಯೂಸ್ಡ್ ಅಂತ. ಯಾಕಂದ್ರೆ ಇದು ಹೈಕೋರ್ಟ್ ರೆಫರ್ಡ್ ಮ್ಯಾಟರ್ ಕಂಪ್ಲೇಂಟ್. ಹೈಕೋರ್ಟ್ ನಾವು ರೆಫರ್ ಮಾಡಿ ಇದನ್ನ ಸ್ಕ್ಯಾಮ್ ಅನ್ನ ಇದು ಮಾಡಿ.
No, see, the concept is that
Yes, yes.
you should give the grounds of arrest, otherwise it becomes illegal. Whether he has been granted bail or not granted bail, charge sheet agide, trial is on. Supreme Court considers everything in an offense concerning UAPA. Will answer it.